Now, this has become the new defense mantra, and this slide actually was given to me by a friend from a defense seminar that was just held about 2 weeks ago on how to defend these cases. Because of the work of Rick Friedman and rules of the road and polarizing the case, a lot of you familiar with that idea of polarizing the case. If they say your client's a liar, you take that head on. Well, they've gotten smart. The defense has gotten smart and more sophisticated. So nowadays, it's easier to prove that your client is crazy or has some psychiatric problem than to prove that they're lying. They now have understood it's very difficult to prove fraud. But so here's the defense. Here's what they're going to do. They're going to look for undiagnosed psychiatric issues. They're going to go back over the medical records and look at any time your client complained of depression or complained of headaches. So you want to have those records first, of course, because we've all, at one time or another, well, some of us, at one time or another have been situationally depressed in life or had problems with headaches. I have Meniere's disease, so I've had dizziness, I've had vertigo. All of those things would set me up for crazy rather than fraud if I ever had a brain injury. Another thing they'll do, they'll consult with a psychologist or psychiatrist to review records. And of course, we're very familiar with the record review thing. And they'll go through and they'll try to find something to attach your client's problems to. And one of the problems with these cases are that the symptoms of brain injury are symptoms that happen in a lot of other conditions. Dizziness, that could be vertigo, that could be Meniere's disease, has nothing to do with brain injury. Depression can be familial, it can be genetic, that has nothing to do with brain injury. Lack of concentration could be all kinds of different problems going on, has nothing to do with brain injury. So you're always going to have, these defenses are always going to be ones you're going to have to educate yourself about and shoot them down. Look for inconsistencies. Of course, this has always been a defense mantra. And finally, remote surveillance of the plaintiff. This is used because a lot of times people with a mild traumatic brain injury, their ability to be mobile, to walk around the room is not affected. So they don't appear to have any problems. And until you talk to a person, maybe 10 or 15 minutes, you don't even appreciate there's something going on. So surveillance can be effective. You can see a person coming out. People can even drive with a mild traumatic brain injury. So you want to make sure your client's aware of that they will be watched. The lawyer's role, have a working knowledge of the issues that I've talked about before. The CDC is a wonderful source, New England Journal of Medicine, or just Google mild traumatic brain injury, and you will get more materials than you could ever in a lifetime read. Gather all the relevant records. This is the number one rule. This is absolutely the number one rule. You want to get all your clients' past medical records. You want to get their past school records, all of that type of stuff, and look at it before the defense takes the deposition. Meet the key witnesses. Know the client's medical and social past, and understand and explain the defense position. What I mean by this is, and this is something that I learned from working with Amy Pardick last year. Give Amy a plug, wonderful consultant here in our state. It's one thing to talk to the key witnesses, and that, you know, we all do that and try to get them relaxed and that. But a step further is when you explain to them, you've been a good friend of Jeff, and you're going to be asked, and the whole defense in this case is to suggest that Jeff has psychiatric problems, that he's always been a little bit goofy. And no, I'm not referring to Jeff Cook. And and you know, let them know that, so that, you know, so that when the offhanded question that they might otherwise not appreciate where this person's going, that they can handle that question. And explain to them why you're going to be asking them how long you've known the person, and you're going to try to get into anecdotes of how they knew the person before. The treating doctors have to know the defenses. The treating doctor has to know if there's anything in the past records about dizziness or headaches. Make sure they know that, because almost without exception it can be explained away. And when you're talking about headaches and dizziness and cognitive problems from a brain injury, it's a whole different thing than an occasional problem with headaches. Pay for the doctor's time in advance. That always helps when you come in the door. It's not privileged communication. Keep that in mind. I've learned that the hard way. The only privileged communication, of course, is with your client. But that doesn't mean you can't be an advocate when you're meeting with a witness. Just keep in mind anything you say or talk about, you would not mind that person telling anybody else, including the jury. And that's really a pretty simple rule to follow if you go into it with that attitude. Explain the goal to the witness and agree on the exhibits. And I'm going to explain what I mean by that here in a minute about the exhibits. How much time do I have? Okay. Practice direct and cross. Now this might just be me, but I'm not the kind of person that can just sketch a few notes and take a good direct exam. I like to write the whole thing out. I don't necessarily have it in front of me when I'm doing the direct, but have your client sit down or have the key witness sit down with you in your office and go through it with them. And have a colleague there and to make sure that you're hitting all the high points. I mean, it just doesn't, as I think George said today, you know, preparation is really the key to these cases. It just doesn't happen in the courtroom unless you're some brilliant lawyer, much more brilliant than myself. This is what you're going to see a lot of times, unfortunately, from defense, to borrow a phrase from my good friend, from defense prostitutes, or even from treating physicians. You'll see this sometime. Because it's much easier to say the person has a personality disorder than to really diagnose and analyze the brain injury. It's much easier to say personality disorder. So how do you counter that? Find out what the friends and the people that have known this person. A personality disorder is a long-standing problem. And when you meet the person and get to know their supervisor and their co-workers, if they didn't have that long-standing problem, whatever that disorder is, this is not something that you know, was long. I mean, this directly counters this defense. And I guarantee you that the expert witnesses that will give this testimony will not have met with these people that you're going to call as witnesses. They won't take the time to do that. So you can really gut this defense if you take the time to meet the important people in the lives of your client. Keep pointing the wrong way. Okay, I'm going to skip over this. The point of this is that I was able to turn this doctor because I went in and met with him and said, "Doctor, you've said in your records here that the client had a severe personality disorder. Were you aware of the fact that Jeff had been a practicing attorney for 25 years, that he was a member of the bar of the state of California, that he was graduate with honors at Earlham College," on and on and on and on and on. And the doctor at trial testified, "I now think his personality changes were likely related to a traumatic brain injury as opposed to a long-standing personality disorder." So occasionally, if you're enough of an advocate and you're just stubborn enough, occasionally you can get in the door and you can turn these doctors. Pay them up front. That's really important.